at this file today, South Coast Behavioral Health, and honestly, it feels like a total collision between two completely different universes.
Yeah, that is exactly the tension at the heart of this deep dive for you today. On one hand, you have a mother's tragedy.
A wrongful death claim that originally asked for $10 million.
Right, $10 million. But
Yeah.
then on the other hand, you have the bankruptcy code, which is just, well, it's cold.
I mean, it's pure arithmetic.
It really is. And we're tracking the specific case of Tiffany Ulrich versus SCBH. We've got the court dockets right from the Central District of California, leading up to where we sit now in February 2026.
And our mission here isn't just to recount the tragedy itself. We need to explain to you how a company goes from a functioning business to a liquidating estate.
Which usually spells disaster for victims seeking justice. And it really starts with a mechanism called the automatic stay.
Right, because Ulrich had originally filed her lawsuit in state court down in Orange County.
She was ready to put her case before a jury. But then in June 2019, SCBH filed for Chapter 11.
And that's the wall, the automatic stay. I mean, it sounds like a pause button, but it's actually a hard injunction.
It is a hard break. The moment that bankruptcy petition gets stamped, every other lawsuit in the country against the debtor just stalks in its tracks.
Which makes sense because you want to prevent a race to the courthouse, right?
Exactly. Without the stay, the first creditor to sue would just grab all the cash and leave absolutely nothing for anyone else.
So Ulrich is stuck.
Yeah.
And she actually asked the judge to lift that brake so she could go back to state court.
She did, and she was firmly denied. That forced a massive strategic pivot. She had to leave the world of juries and emotional appeals and enter bankruptcy court.
By filing proof of claim number 27.
Right.
And this is where the numbers just make my head spin. She starts at $10 million and ends up settling with the trustee, Thomas Casey, for $75,000.
It is a massive capitulation.
So why fold like that?
It's all about litigation risk. The trustee didn't even agree that SCBH was liable. If she wanted that $10 million, she would have to fight a mini trial inside the bankruptcy court.
Which takes years and costs a fortune in legal fees. So she takes the deal. But the sources highlight something I found confusing.
The allowed general unsecured claim part.
Yes. She settles for $75,000, but she doesn't actually get $75,000. Translate that.
Think of it as an admission ticket. The allowed part just means the court agrees the debt is real and liquidated at that specific number.
But having a ticket doesn't mean you get a seat on the bus.
Exactly, because the bus is full of other people who get paid first. It's what we call the waterfall.
The strict hierarchy of who gets paid when a company dies.
At the very top, you have administrative claims like the trustee's fees and the lawyers. Then priority claims like taxes.
And the victim.
General unsecured creditors, like Ulrich, are at the very bottom.
Yeah.
They only get paid if there is money left after everyone above them is paid in full.
Which brings up the burn rate our sources mentioned.
Yeah.
I saw a settlement for a group called DPM for $39,000.
An administrative claim, yes.
So every single dollar paid to DPM or the lawyers managing the estate is a dollar that cannot go to Ulrich.
It is a brutal zero-sum game. Even with her allowed claim, she is only going to get a pro rata percentage.
A slice of whatever is left.
If the estate only has enough assets to cover 10% of the unsecured debt, she gets a check for $7,500.
Not the $10 million she wanted, and not even the $75,000 she settled for. That is incredibly bleak.
It is. And we are in the post-confirmation phase now, early 2026.
Waiting for the math to finally resolve.
There is a status report due April 14th and a conference on April 28th. That is when we will finally see the net distributable assets.
Basically, how much cash is actually in the bank after the lawyers take their cut? Is there any upside here at all?
The sources do offer one counterintuitive point. They contrast this strict federal process with the chaotic regional state courts.
Right, the Wild West of local litigation.
They cite attorney misconduct in Southern California, mentioning cases dismissed for lack of prosecution by lawyers like Norman Gregory Fernandez.
Okay, so the argument from the sources is, sure, you get pennies on the dollar in bankruptcy, but at least the federal trustee isn't going to botch the procedure and get your case thrown out entirely.
In a way, yes. The bankruptcy process is absolutely ruthless, but it is orderly. Trustee Casey ensures the rules are strictly followed.
It protects the claimant from the procedural chaos of regional courts, a trade-off between chaos and a clinical low-payout order.
Precisely. The emotion is totally stripped away.
Mm-hmm.
We aren't really talking about a son's death anymore. We are talking about line items in a ledger.
Which brings us to the end. The source material leaves us with a really heavy concept. SCBH is liquidating. It's becoming a corporate shell.
When the process ends, the company ceases to exist. It doesn't even get a discharge of debt, it just vanishes.
And the debts vanish right along with it. Leaving you with this to mull over, we built a brilliant legal system to handle money. But did we forget to build one that handles accountability?
That is the real question.
When the bank account hits zero and the corporation dissolves, does justice just evaporate into thin air?